Thank you. There will be three objectives to this session, session 4. The first objective is to bring all members of the audience up to speed on the terminology of cross-border insolvency. The second objective will be to explore ways in which international commercial courts can become involved or more involved in cross-border insolvency, especially the Singapore International Commercial Court. And the third will be to try to suggest ways in which members of the audience who are interested in becoming more involved in cross-border insolvency might do so. How might one develop an interest or even a career in cross-border insolvency? Let me begin by asking a question of Jamie. And what, in a nutshell, is cross-border insolvency? Is it important, and why, that insolvency proceedings involving a company having assets in different countries be coordinated from one jurisdiction? Jamie.
Yes, thank you very much for having me on this esteemed panel. So as to what are international insolvency proceedings, if you step back, these days almost any company, not just the very large ones, if they get into a troubled situation, are going to be classified as some type of international insolvency proceedings. And why do I say that? It could be a classic Lehman Brothers type of thing where there's multiple international entities in multiple countries, and the creditors are from all over the world, and the documents have many different choices of law depending on what the various contracts are. Or it could just be a single entity in a single country, but even when you drill down on that, most of those entities these days have creditors, trade creditors, who are located in other countries, and there's some cross-border element. And so it's a very broad swath of defining cross-border insolvency proceedings these days, from small companies to very large companies. As to the importance of some sort of centralization factor, I think actually that was touched on in the opening remarks of the Honorable Chief Justice, where he talked about the problem of fragmentation. And what cross-border insolvency proceedings really do, if you want to put it in a nutshell, is sort of the opposite of fragmentation. They try to centralize proceedings in one place, with the overarching goal being the maximization of the value of the enterprise to the greatest benefit of the creditor body taken as a whole. Obviously, we then get into details of prioritization and secured and unsecured, et cetera. But that's generally what we're trying to accomplish. And it's incredibly important because my experience is if you don't address that and there is fragmentation, it's incredibly destructive to value, again, as a whole. And when there's less of the pie to go around, even if people are fighting over slices of the pie, you'd rather fight over as big a pie as possible.
Thank you. Let's move to Sushil. We often hear the term the Center of Main Interest, COMI, C-O-M-I. What exactly is the COMI, and how does one determine what the COMI is in a given case? Sushil.
Thank you, Justice Reyes. The COMI, as you say, the Center of Main Interest of a country, its main relevance nowadays in relation to cross-border insolvency is that the model law issued by UNCITRAL, which is aimed at avoiding the fragmentation that Jamie was just talking about, suggests that the jurisdiction where the COMI is located would be the jurisdiction that would take the lead role in a cross-border insolvency. For example, if there was an insolvency where you had a company, a holding company in Singapore and then subsidiaries all over the place, the Singapore court, if Singapore was the COMI, would take the lead role in managing that. So what is the COMI? In determining what the COMI is, in a nutshell, it is the place where the bulk of the business is carried out, where most of the dealings occur, and where most of the monetary transactions take place. ultimately is where the main decisions are made. Now, there is a rebuttable presumption in most jurisdictions that the COMI is the jurisdiction of the registered office of a company. So your start point would be, okay, where is it registered? And that would be the COMI. But obviously, there are certain jurisdictions where registered offices are simply for the purposes of the registration. The Cayman Islands, the BVI, that happens, whereas the entire operations and management of the business take place somewhere else. And in that situation, it becomes a fact, looking at the circumstances, whether the presumption registered office is the COMI has been rebutted because all activity takes place elsewhere. Now, I've got to say that there are nuances between different jurisdictions as to what that level is. I think in the United States, you're looking pretty much at what the nerve center is, and so it's quite a high bar. Other jurisdictions look towards what the objective and ascertainable source of management is. But ultimately, it's on the facts. If management and most of the business is carried out in a particular jurisdiction, that would factually be the COMI.
Thank you. Let's move to Ramesh. Now, Singapore has adopted the UNCITRAL model law on cross-border insolvency. Sushil mentioned that a moment ago. We've also heard about the American Law Institute's global principles for cooperation in international insolvency cases. The ALI, the American Law Institute, also has global guidelines for court-to-court communications, international insolvency cases, and global rules on conflict of law matters in international insolvency cases. Can you just compare and contrast? What's the difference between the UNCITRAL model law and these ALI global guidelines? Is one better than the other, or is it a matter of taste whether you go with one as opposed to the other?
Yes, thank you very much, Justice Reyes. There are two different instruments and they serve quite different purposes. The UNCITRAL model law on cross-border insolvency is a legislative instrument, and being a legislative instrument, it has to be adopted by the legislature to have force of law in the same way as, for example, the model law on international commercial arbitration. So if you don't have Parliament adopting it by way of legislation, then it doesn't assume force of law in a jurisdiction. On the other hand, the American Law Institute's Global Principles for Cooperation in International Insolvency Cases is not a legislative instrument. It is a non-binding statement that was offered by the authors or the reporters, and I'm quoting from the reporter in this case, for endorsement by leading domestic associations, courts, and other groups around the world. The principles were commissioned, or rather the project was commissioned in 2006 by the American Law Institute and the International Insolvency Institute as a joint project, and the objective was to provide a non-statutory basis for cooperation in international insolvency cases. The result was the publication of the three principles that you mentioned in a 200-page report titled Transnational Insolvency, Global Principles for Cooperation in International Insolvency Cases. And the reporters for the project were Professor Ian Fletcher, who's no longer with us, and Professor Bob Wessels, which Lexa referred to earlier. And the publication was made on the 30th of March 2012. So they serve different purposes. One is hard law, the other one is soft law, as it were.
Thank you. But sticking with you, Ramesh, we've also heard about the Judicial Insolvency Network, the JIN. What exactly is it, and what is Singapore's role in the JIN?
So the Judicial Insolvency Network, you might have read about it or you might have heard about it. It is a network of insolvency judges from various jurisdictions across the globe with a deep interest in cross-border insolvency work. The network was initiated by the Honorable the Chief Justice Sundaresh Menon as a forum for providing three things. One, judicial thought leadership. Two, developing best practices in cross-border insolvency. And three, facilitating cooperation and communication in cross-border insolvency and restructuring matters. The birth of the JIN, which was in 2016, saw the issuance of the JIN guidelines, and the JIN guidelines really give flesh to the obligation to cooperate and coordinate in Articles 25 and 26 of the model law. And of course, they are of general application. They're not limited to the model law, but in substance, they give flesh to Articles 25 and 26 of the model law.
Now, perhaps we move on to Lexa here. To date, some 49 states, I think, have adopted the UNCITRAL model law on cross-border insolvency. Examples are Australia, the US, the UK, Singapore, and Japan. Examples of states which have so far not adopted the model law are China and India. Can you bring us up to date on the position in the EU? And then, as a second question, would it, in your view, facilitate the conduct of cross-border insolvency if more states were to adopt the model law on cross-border insolvency?
I can start with the last question first. I think because the UK has now exited the EU, for us, the more states that adopt the model law, the better, frankly. And in particular, probably more states in the EU, the better. At the moment, I think there are only 4 states in the EU that have adopted the model law: Poland, Romania, Greece, and Slovenia. And it doesn't look like other states are going to adopt the model law anytime soon. And one of the reasons for that is, of course, the EU states have their own EU regulation for cross-border recognition of insolvencies within the jurisdiction of the EU amongst the states whenever there is an insolvency in an EU member state. And the problem is in adopting, or the states adopting the model law, is that each state has an intent to determine whether they want to adopt the model law or not. It's not something that the EU Commission can, if you like, impose on all the member states without the member states agreeing. So each member state has its own independent right whether to adopt it or not. And it may well be the case that they consider actually that at the moment, in any event, the EU regulation provides them with sufficient laws in relation to cross-border insolvency. There's also been a recent, very, very recent article by Professor Wessels, which Justice Ramesh referred to. He's a professor emeritus at Leiden University and also expert counsel to the European Commission on restructuring and insolvency. And he started his article saying that he's feeling pretty grumpy. And the reason why he says he's feeling pretty grumpy is because UK insolvency professionals keep on criticising the EU now for not adopting the model law. And what he points out, in fact, is all right, a lot of EU states haven't adopted the model law, but they do have domestic legislation which is more or less equivalent to the model law. And therefore, it's just a question in each state, for example, Germany, Belgium, the Netherlands. It's a question of identifying in each state what their laws for recognition are. And Bob Wessels' view is that they are very closely aligned with the model law. So I'd say in an ideal world, it would be excellent if all EU member states adopted the model law, because then there wouldn't really be that many. We would just have to go to one instrument and not go to each country's instrument. But it doesn't look like that's going to happen anytime soon.
Let's go back to Jamie and still exploring these UNCITRAL model laws. Let's go to one that's hot off the press. That's the UNCITRAL model law on group insolvencies. Can you just tell us a little bit about its underlying concepts? And perhaps a follow-up question on that, does it have any potential for planning proceedings in the SICC, in an international commercial court?
Thank you. Yes, and I think it follows on very well from the comments that were just made. First of all, it's nascent in the sense that it hasn't actually been adopted by any country yet, formally. But what the genesis of the model law on group insolvencies is the recognition that when I talked about at the onset of this panel, what is an international insolvency proceeding, I actually didn't break it down by entity or entities. But as we all know, any company, and put that in quote marks, that operates internationally is more likely going to operate in multiple entities and call that a group. And so the current model law only applies to the entity. So if you have an international entity, an international group with, say, 12 entities, under the current model law, those 12 entities, each one of those is individually dealt with by the model law, the current model law. The group insolvency law attempts to sort of recognize reality of the way companies operate as a group practically, and again, deter fragmentation and encourage maximization of value. And how do they do that? They do that by what you just mentioned, Justice, which is the planning proceedings. And so let's again use 12 entities. I'm making that up. I've been involved in some that literally have hundreds of entities, but even if it was 2 or 3 entities, the group proposed model law applies, and you would have a planning proceeding in the sort of what I'll call the COMI for the group that Sushil was referring to on an entity by entity basis. But here it would be sort of the most logical place for where this planning proceeding ought to proceed, and you would try to chart out a path to handle the group insolvency in a coordinated, value maximizing way. And the SICC is tremendously placed to be of assistance in that regard, in terms of being a situs for a planning proceeding of a group of insolvent entities. Now, I mentioned that so far, and it's relatively new, it hasn't been adopted by any country, but I actually believe that is not an impediment at the present time. If, for example, a group of companies or one entity that comprises a group were to file in the SICC, I think, and I would leave it to Ramesh, to comment, but I don't see why the intellectual principles and the organizing principles couldn't be applied even now without the model law being enacted. There's obviously some impediments because it's not formal law, but just like we talked about the ALI guidelines, for the moment until it's enacted in certain places, I think it could be referred to as an organizing principle.
Thank you. We'll go to Ramesh in a moment. Perhaps I could go back to Sushil and Lexa and invite them to tell us a few war stories, to give us a feel about what cross-border insolvency is all about. Sushil, why don't we start with you? Can you give us examples of typical cross-border insolvency disputes, drawing on your own experience, and what techniques are normally used to deal with such disputes?
Well, I can tell you that we had a situation with an Indonesian company, which had a presence here as well, where we had to deal with a situation where the funds for that company, capital was raised in Singapore through an SPV, which was guaranteed by the Indonesian company. And therefore, all the banks and financial institutions had put in the money on the basis that it was a Singapore governed transaction. But obviously, the business and a lot of the trade creditors were all in Indonesia. And in trying to come up with a restructuring, the banks wanted it to happen here in Singapore. But Indonesia was not going to recognize a Singapore restructuring because not only is it not a model law country, it would only accept a restructuring that happened there. And so we had to come up with something where we could deal with the banks, get a restructuring done here that they could live with, and we had to deal with the trade creditors as well. So we ended up having to do it in 2 stages. We did a Singapore restructuring, and that restructuring dealt with the financial creditors. And to be fair, that was the bulk of the liabilities of the company. A scheme of arrangement was done in Singapore, and to prevent anybody from taking steps in any other jurisdiction, because this was a shipping company, we went and got Chapter 15 recognition in the US for the Singapore scheme. But we also did a concurrent scheme in Jakarta, in Indonesia, to deal with the trade creditors. And we made both schemes interdependent, which in other words, if one scheme failed, the other one would fail as well, because without getting the trade creditors on board, it wasn't going to work. It was an interesting exercise, given that obviously the jurisdictions are very different, the legal systems are very different, but everybody had the same desire to get the deal done. And so we had to manage the expectations of the trade creditors, given that they were looking at what the financial creditors were getting in Singapore. We had to manage the courts. But in the end, it worked. We managed to get both restructurings done, recognized in both sides. But obviously, if we had had the advantage of the other jurisdiction accepting the model law, and it would have been easier to have run it out of one jurisdiction. But that was one time we had a bit of a real difficulty, which we managed to resolve. And we resolved it using 3 jurisdictions. I mean, getting the Chapter 15 was very helpful in preventing. Like it or not, I can tell you that even though the Chapter 15 moratorium is not necessarily a worldwide moratorium, people tend to take it seriously. And so we tended to use that to stop arrests from happening in a number of different jurisdictions. While we had the moratorium in Singapore, keeping the banks all honest, and the restructuring in Jakarta.
Now, what about you, Lexa? Can you give us a feel for a typical cross-border insolvency dispute?
Well, I can give you an example from some years ago where Alitalia was in an insolvency process in Italy, and it was seeking, the insolvency practitioner was seeking to recover and collect in assets from all over the world, including the UK. And of course, the UK at the time was member of the EU, and therefore the insolvency proceedings in Italy had been automatically recognised and in the UK, and therefore the insolvency practitioner in Italy, for whom I have to say I acted, wanted to collect in a very sizable sum of money sitting in a bank account in the UK. On the other hand, there were a large number of former employees of Alitalia in the UK that if they simply waited for the insolvency process in Italy to effectively work its way out, they would only get a small dividend in the pound. So what happened was that the employees opened up what we call secondary proceedings in the UK, which were perfectly permissible in across the EU. If you can establish, the rule is within the EU that if the centre of main interest is in a EU state, that's the only place where you can open what's called main proceedings. But if you can demonstrate that there is an establishment in another member state, you can open what's called secondary proceedings. And that's what happened in the UK. And on behalf of the Italian liquidator, I argued that there was no establishment because effectively Alitalia had closed itself down, but there still was an office there. And the effect of the judgment is that that Alitalia did have an establishment, and the liquidator that had been appointed in the UK was entitled to take control of that sum of money sitting in the bank account in the UK and distribute it within that establishment insolvency, and effectively deprive, I would have said, the larger class of creditors in Italy from that sum of money. But that's the way in which the EU regulation works. You have main proceedings, but in the right circumstances, you have secondary proceedings, and assets located in the jurisdiction of the secondary proceedings belong, in the first instance at least, to the liquidator and the creditors proving in the secondary proceedings.
And let's go to Justice Ramesh Kannan on this to pull all the themes together. We've heard Jamie on group insolvencies. We've heard Sushil lamenting that he had to deal with 3 different jurisdictions. We've heard Lexa talking about the COMI main proceedings and secondary proceedings. My question is this: what role can the Singapore International Commercial Court play in these cross-border insolvency cases? And I'd like to make my question a bit more specific. When I'm saying what role can the Singapore International Commercial Court play, what difference does it make? Why the SICC as opposed to an ordinary commercial court, a domestic commercial court anywhere else in the world? What role can SICC especially play?
Thank you, Justice Reyes. I think the short answer to your question is to accept the point that there are nodal jurisdictions. And once you accept that there are nodal jurisdictions or control courts, there are various terminologies which have been used to describe such jurisdictions. I think Professor Westbrook likes the term control courts. I like the term nodal jurisdiction. I think that's a term that the Chief Justice has used as well. Once you accept that there are nodal jurisdictions, then I think you will understand that the SICC may have a role, or there's a strong argument for the SICC having a role in resolving cross-border insolvencies. Now, if you go back to the architecture of the model law, and then if you extrapolate to the architecture of the model law on group insolvencies, you'll understand why I make the point. The first point is the architecture of the model law is built on modified universalism. So you go back to the SICC court, which is the COMI court, and you have the eligibility to open secondary proceedings, but those are secondary proceedings which are really ancillary to where the primary resolution of the insolvency is taking place, which is the COMI jurisdiction. There are solutions to not opening secondary proceedings, and I'll come to that. Now, if you then transpose that, and as Jamie pointed out, the model law architecture assumes a single debtor restructuring across borders. Now, companies are no longer organized on a single debtor basis. Their businesses are now involve multiple entities spread out across the globe, but it's a single business unit. Or most often, it may be a combination of several business units, but functioning as a single economic entity. And when the entity fails, the business, the whole group fails, you need to restructure holistically and treat the group as one. And that's where the model law on group insolvencies come into play. Now, the model law on group insolvencies has 3 principal features, which I think are important to remember and which may be relevant to the SICC. The architecture, the edifice of the model law on cross-border insolvency is the planning proceedings. Now, the planning proceedings is where the entire conversation on the group restructuring plan is focused. And it's important to pick the right court to seat the planning proceedings. Because and the planning proceedings is where you get the group insolvency solution being developed, that is for the entire economic entity, the plan for the entire economic entity, as well as where you have the group representative being appointed. So when you accept those principles, and I take Jamie's point, those are principles which are portable to any situation. You don't have to adopt the model law to bring these concepts into play in any restructuring. Once you accept that argument, then the big question is, where do you seat the planning proceedings? And why do you seat the planning proceedings there? And that brings me to the point that that seat has to be a nodal jurisdiction. Now, what is a nodal jurisdiction? A nodal jurisdiction is typically a key financial center with a strong rule of law framework, a deep pool of insolvency professionals and people experienced in the field of insolvency who can facilitate the development of a good restructuring plan. It also, a typical nodal jurisdiction will be also one where you have a strong bench of experienced judges who understand this area of work and who can facilitate the right restructuring conversation. So once you have those conversations, those elements in as a feature of the nodal jurisdiction, you will then understand why the SICC straight away comes into the conversation. The SICC is cited in Singapore. We are a key financial center. We have in the SICC we have a bench of international judges as well as domestic judges who are experienced in this area. We have got a strong legislative framework for restructuring and insolvency, much the same way as Chapter 11 in the US. And we have a pool of insolvency professionals, both onshore and offshore, who can facilitate that discussion for the development of a restructuring solution. So from that point of view, the SICC can play a role, certainly for this neck of the woods in terms of finding solutions for ailing companies.
Let's go back to Jamie on this. We heard the Chief Justice earlier today in his opening talk a lot about mediation. Is there any scope for using ADR, alternative dispute resolution, mediation and arbitration, as part of plan development? Can the SICC play a role in the use of ADR in relation to cross-border insolvency?
Yes, I actually think there is a large scope for it, and it really plays off what was just talked about with nodal jurisdictions. And what I mean by that is, the base case for, in my experience, constituencies being willing to be in mediations or some sort of ADR proceeding is, I always call it, compared to what? People are always comparing it to what will happen if they take it all the way to a decision before the justice. And if it's in a jurisdiction where there's a strong rule of law, it's clear what the insolvency principles are, it's relatively clear what the priorities are, and within some spectrum, there's still a dispute, but you can sort of handicap what might happen if you take it to a contested, adjudicated decision, then that actually enhances the ability, in my view, for mediation to occur to actually avoid that result. If you're in some jurisdiction where the rule of law is not so strong and things happen that shouldn't be happening, or there's not a reasonable spectrum of where the decision can come out, it's an incredibly wide spectrum. I've found that people are less willing to engage in mediation. So, keying off what Ramesh was saying, because you have that dynamic already in Singapore, it's possible to avoid the time and expense sometimes of going all the way to the contested decision and have some sort of mediation. In the U.S., we do it sometimes with private mediators, sometimes with a judge or justice who is not on the case at hand, but is appointed just for mediation purposes. And there's spectrums in between where we've had multiple mediators. But I think there's a lot of spectrum for that. And it's more difficult than in your typical situation where there's maybe two parties in a non-insolvency situation, because you could have any number of parties in an insolvency situation that need to be brought into the mediation, and what the sequencing of that is and the choreography of that is incredibly important. But that's where you need a skilled mediator with experience in doing that. And so I believe there's a lot of scope for that, and it can really be constructive. Again, if we go all the way back to the main goal is the maximization of value of the enterprise for the greatest good of all the creditors and the company and the employees, mediation could be very helpful.
And what do you say, Lexa? From your own experience, do you think mediation has any prospects with cross-border insolvency?
I can understand that it does have a strong role to play where you're dealing with multinational companies across borders, and you've got a large number of different competing claims, and that the collapse is one that is just fortunate rather than one that has been driven by fraud. Where I feel less comfortable is the idea that where you have a collapse as a result of wide scale, or not even a wide scale, but some fraud, insolvency is not just a private matter between a company and creditors. There is a public interest there, and I have concerns about claims which involve substantial clawbacks or transaction value or fraudulent trading being mediated private without the public being able to see the wrongdoers being held to account. Now, I mean, at the moment where there are claims arising, claims in fraud and so forth arising out of insolvency, it's not the case that such claims don't resolve themselves by mediation or some form of ADR. So I can't say it should be prohibited in all circumstances, but I think it need to be careful in effectively drawing a cloak over all forms of restructuring, so that it's actually there is a veil between what's going on in the restructuring and the public. The public need to see and understand what is going on, because ultimately, if there is a big collapse, although the public may be far along the line, they suffer as well. So I think that there needs to be moderation there. You know, the sort of rush to mediate and to appeal to all forms of ADR is not, I feel, the answer to all problems that arise in a cross-border restructuring situation.
Sushil, do you have a take on this, on mediation or other forms of ADR in cross-border insolvency?
I do. I take Lexa's point in relation to fraud, but mediation, I think, could be very useful in relation to cutting down the time needed to bring different classes of creditors together. Because sometimes in putting together, when you have an insolvency process that involves a restructuring, you have a group of creditors ultimately whose interest is the same. I want to get as much as I can. The trouble is that everybody is acting in their own interest, and you have a long drawn out discussion as to why this person should be getting less and this person should be getting more. And you will find at the end of 8 to 10 months, the difference between where you started out with and where you end up with is so minuscule that you've wasted 10 months for nothing. And so I can't help but feel that even when it comes to, especially a regional restructuring, when it comes to the financial institutions, having a senior banker, for example, a senior financial player, start walking through the different returns that each of the institutions would get very early on. Someone who has no skin in the game, trying to get people to take a rational view as to what returns should be, would cut the process down considerably. I mean, another area where this could probably work would be in terms of your note holders and your bond holders, especially when they're not institutional players, if they're retail players. The trouble with having a bunch of retail note holders is that it's a very personal thing for them. They've put money into notes, which it's their personal money. They feel very aggrieved that the company is in trouble. And so a decision is made not because of the financial responses, but because of an emotional response. And having somebody who is a respected person deal with them, someone, again, with no skin in the game, to deal with them and say, listen, this is exactly where the company is right now financially. You stand to get nothing. We're going to see and find a way to get you something, could work and cut down a restructuring process considerably. So I am strongly of the view that there is scope for ADR in a restructuring or insolvency process that would cut down and the time considerably, and that enhances value for everyone.
Perhaps we go to a different theme now, and then I'll go and ask a few questions that the audience have raised. This theme is, how did one first become involved in cross-border insolvency? How did one suddenly become interested in cross-border insolvency within one's own career? Let's start with you, Lexa. How did you become involved in cross-border insolvency? What has led to a career in cross-border insolvency?
Well, I started actually I started as an academic at Durham University, and I taught contract and conflicts of law there. And then I decided, all right, I'll become a barrister, and I did my pupillage at a set of chambers called Fountain Court. And much to my dismay, I wasn't taken on there, but they recommended that I applied to South Square. And I applied to South Square, who are, as you know, are very well known in the insolvency field. And they were interested in me, but I said, well, I don't know anything about insolvency. It's not anything that I've ever studied. And they said, well, you don't need to know anything about insolvency. So I joined South Square, and I spent about 18 years there. And of course, I got to know a lot about insolvency. And it is a really fascinating area because unlike in a lot of areas that barristers practice in, it's not narrow, because obviously if a company or a group of companies collapses, it raises all kinds of legal questions. So one day you could be dealing with fraud, the next day with a breach of contract claim, the next day with a negligence claim, the next day with a patent claim. It's very, very varied. So that's how I ended up having a specialism in insolvency.
Let's go to Jamie. What sort of advice would you give? Let's say I have a young, ambitious law student who says, I'm very keen and interested in developing a career in cross-border insolvency. How would you suggest that young law student lawyer get started?
Well, as was just noted, you have to start somewhere. So the fact that at that time the individual doesn't know anything about insolvency should not be an impediment. But there are, as we've talked about here, any number of laws that have been formulated by various organizations that try to organize and make more efficient the international insolvency world. And those laws actually, or guidelines, get put together by these groups that are all composed of folks from all over the world that got involved in these organizations many times as youngsters and worked their way up in these organizations. So, for example, I was very involved in INSOL, which is probably the preeminent international insolvency organization with more than 10,000 members around the world from almost 100 countries. And you don't just go into that organization and start writing ALI guidelines on how to proceed around the world, but you can start going to conferences and be involved in committees, and there's all sorts of publications, both online and recorded, not recorded, to get you up to speed. And so it is a process, and you have to sort of ooze the international issues over time. But I always tell folks, and one of the very interesting things, I like the term that it's very varied, that I just heard. I call it embrace the chaos and ambiguity. And to me, that's one of the things that keeps life interesting, in that many times there's just not clear answers. It's a world of gray, and it's not black or white or yes or no. And so people have to get themselves comfortable with that. But you do that, and you not only learn the substantive law over time, but you become part of the important ecosystem of practitioners, government officials, judges, justices acting in various capacities, non-legal folks of restructuring consultants. And it really is an ecosystem in each country, but really around the world. and it takes, a decade would be a short time to get yourself comfortable with it all, but you can learn a lot in a few years, and you start developing relationships with individuals and organizations, and that's how you hopefully get into the international insolvency world.
Sushil, let's get at the question from a different angle. We heard from the Chief Justice earlier this morning that with the financial recession that has come in the wake of COVID-19, there are likely to be more insolvencies and cross-border insolvencies. From your position in your day-to-day work nowadays, is that prognosis a correct prognosis? Are there likely to be a lot more cases and big cases on cross-border insolvency?
I think in two senses, yes. In one sense, we've faced a position where we're halfway through significant restructuring exercises, which involve the investors and raising money, and you have an investor that's interested in coming in, and then COVID struck, and the investor takes a suddenly different view when you're halfway through the process, and you're now scrambling to try and find other investors, trying to ensure that protection continues for the company, or reducing everybody's expectation because the investor says, yeah, I'll come in, but this is all I'm going to put in now, and so everybody has to accept that the world has changed. And the difficulty is that in some cases, people don't understand that change has happened. People take aggressive steps against companies. And that is a problem that I think might be suffered worldwide. It's important for people to realize that for a year, a number of companies that may have already, because let's not forget, even before COVID happened, the world was already moving into a slowdown. We had the oil and gas crisis, shipping was in trouble. There were a number of companies in deep restructuring trouble. And then COVID happened almost like a double whammy to move everybody further down. So I think there will be a number of significant cross-border restructurings coming up because companies that were trying to work things out during that difficult time got hit again, and people are adjusting to the new reality. But there's also going to be a great deal of work for existing restructuring, which in a sense is going through a second process of restructuring now. As we go back to the parties, everybody had agreed on certain things. Reality has changed. Everyone has to understand that it's changed. And so you're renegotiating a position where you almost had a deal 12 months ago. There's a fair bit of work out there. And so I think the pandemic will cause more of that to come on our plates, unfortunately.
So we've heard about this atmosphere of there's likely to be a lot more work coming on. Hopefully, having heard Jamie's and Lexa's experience, a lot more lawyers in Singapore especially will become more interested in this. Ramesh, can you just give us an idea of what steps the SICC will be taking in the future to develop its field of cross-border insolvency? For instance, will there be a specialist insolvency list? Or will there be a subsector, an insolvency court within the SICC?
Well, I think the issue is being considered. That much I can say. There's obviously a need to ensure that the SICC has the jurisdiction to hear such matters, and that's an issue that's being explored. There is also, and Jamie will know this, a group that is looking into formulating customized or specialist rules for insolvency and restructuring filings in the SICC. So in a sense, coming up with state-of-the-art procedural rules for cross-border insolvency matters which are filed in the SICC. Obviously, the SICC has international judges, so the possibility of international judges appointed to hear insolvency matters is there. That's something that's not for me to decide. It's for the Chief Justice to take a view on. But certainly these are three. The first two are certainly being considered and looked at very carefully. The third is obviously a possibility.
Let's go to some questions that the audience has asked. The most popular question is this: what is the difference between the role played by national courts and international commercial courts in the area of cross-border insolvency? Perhaps, Ramesh, you'd like to try that one?
Well, I think the role is the same. It's really the ecosystem that's critical, and it's really where the nodal jurisdiction point, which I made earlier, that's absolutely key. It doesn't matter whether it's an international court or a national court. It really comes down to whether the court has the tools, that is the hard law, to restructure. The jurisdiction has the attributes for a restructuring culture, that is a debt restructuring environment, a good pool of professionals, a debt trading market, a debt financing culture, and so on and so forth, which are all key attributes for restructuring, which has made, in a lot of ways, London and New York great centers for restructuring. So if you look at it from that point of view, it doesn't really matter whether you call it a badge, the court, a national court, or an international court. It really comes down to where the court is cited and what attributes that particular jurisdiction has.
The next most popular question is from William Visser, and it's this: does the SICC offer restructuring proceedings comparable to the English scheme and the recently introduced Dutch scheme? I'll ask Lexa for the second part. What are the English scheme and the Dutch scheme of restructuring proceedings?
I'm sorry, I don't think I can really help you with the Dutch scheme, but I can obviously help you with the English schemes. We've got now two English schemes. We've got schemes of arrangement. We've got one of great antiquity, whereby a company or its creditors actually can make an offer to either all its creditors or to a class of its creditors. And if 75% in value and 50% in number agree to the proposal, the court eventually will consider the proposal and decide whether to sanction it. And in determining whether to sanction it, they apply principles of fairness, which in broad terms mean that the court considers whether the scheme is fair, taking into account the interests of all the creditors, and even those creditors that have voted against or not voted at all. Most recently, at the end of last year, Parliament introduced a new sort of scheme, not so dissimilar from the old scheme, but now it's possible to what we say cram down a class of creditors who, in the event of an alternative to the scheme, it can be shown would actually be no worse off, or potentially even worse off. So, for example, you've got a class of creditors who are standing outside the scheme and being a potential impediment to the scheme, but it can be shown that actually in relation to that class of creditors, if, for example, the scheme was not approved and the company was forced into some formal insolvency process, that class would be no worse off. Then the court can go ahead and approve the scheme. And that's a somewhat radical departure, because under the old scheme, if that particular class of creditors was put into their own separate class, they could effectively hold the scheme to ransom, because they could say, well, even though we wouldn't be any better off in a liquidation, we're not going to approve this, unless, for example, you give us a lot more money than we would otherwise be entitled to if the company went into a formal liquidation process. Now, we've had a couple of schemes like that have been approved, but they haven't actually really been very controversial as yet. But I dare say that in the months and years to come, there will be cases where the class that is being crammed down is going to argue that the relevant alternative would actually provide a better outcome for them than the scheme, and then there will be lots of expert evidence on whether that would really be the case. So those are the two English schemes. I'm sorry I can't assist in relation to the Netherlands one.
That's all right. Now let's go back to Ramesh. Will the SICC be involved in restructuring processes similar to those described by Lexa?
Right. So I think the process that Lexa talked about is a Part 26A application, which is the new format, and I think the key difference, and I think this is based on Justice Anthony Zachary's recent judgment in Gate Group, is the difference between the Part 26 scheme, the original scheme, as it were, and the Part 26A scheme, is that the new process is predicated on insolvency. You need to show financial difficulties before you can avail yourself of 26A, and yes, it comes with cram down powers. To that extent, it is similar to what we have, which is the previous Section 211B application, which is now under the IRDA, where you can cram down across classes. There are differences between the way we cram down and the way it will be done in the UK, but in terms of the tests that one applies, it's not very, very different. So the legislative architecture in Singapore for our scheme regime, if you invoke that particular regime, the regime that's akin to 26A, is somewhat similar. There is one distinction. Our scheme regime is not predicated on insolvency, unlike 26A. So the basis for filing is a little different. But having said that, cram down is an option that's available, as is dip financing as well. So yes, the answer is yes, and it's a little bit more than yes.
Thank you. Let me ask Jamie one of the questions. It is the mediation to which you were referring to a moment ago. Is this not to be spearheaded by the trustee in bankruptcy? So it's the trustee in bankruptcy who should be taking the initiative in mediation. What would you say to that, Jamie?
Sometimes it is initiated that way, or in my world, the debtor in possession. Sometimes it comes from the judge, and sometimes it comes from important creditor constituencies. So it sort of runs the gamut. I would say one of the sort of semi-dangers of the mediation is that it freezes constituencies from making concessions in anticipation of a potential mediation. So that is a downside that is to be avoided. But in some of these complicated situations, and I take very much that it doesn't, in a fraudulent situation where there may be criminal conduct, I don't think mediation is really the right way to go. But in where there's just general, what I'll call incompetence, that cause the problems, it can come from really any of the important parties.
We have just under 2 minutes. Perhaps I just ask a few more of the audience's questions. Sushil, there's a question on the influx of insolvency cases was mentioned earlier. How are the existing rules practiced on insolvency and restructuring, especially in the SICC, equipped to deal with this? How could they be improved? Would you be able to give your view on this? Do you think the existing rules are adequate? Do they need improvement?
I mean, as Ramesh says, it's a question of the fact that Singapore is already a nodal jurisdiction. What are the laws that we have to deal with insolvency and restructuring, having been adjusted over time, I think deal very, very well with the situation. You know, we started out with purely using the English system, right? And the scheme of arrangement was basically close to what the English system scheme of arrangement was. And then we looked to Chapter 11, and we started to pull together the best of both. We still have the scheme of arrangement. We still have cram downs based on the original concepts. But now we've got dip financing being brought in. We've got cross-class cram downs being brought in. And recently, I say that because it's an indication of how quickly we adjust to the needs of the time. Recently, the ipso facto provisions came in to make it difficult for parties to rely on ipso facto clauses where a scheme of arrangement has taken place. These are all provisions of the law that I think already provide the SICC and our Singapore courts with all the tools needed to carry out a proper restructuring. Indeed, I think by bringing in the various concepts that we have from Chapter 11 and adding them to the existing scheme of arrangement concept, including worldwide moratoriums, provided that the parties that it is imposed on are within Singapore's jurisdiction. These are all tools in place that allow us to deal with a multitude of issues in restructuring. So I think that the SICC, I think the Singapore High Court, very, very well placed to deal with cross-border restructuring and cross-border insolvency issues, because we have both got the rules in place, but we've also got the ability to adjust quickly if there was a need to.
Thank you very much. I think we've run out of time. I'd like to thank all the members of the panel for spending an hour or so on discussing cross-border insolvency and introducing cross-border insolvency to our audience. I'd particularly like to thank Lexa and Jamie in particular. Jamie, because I believe it's early in the morning, very early in the morning his time, so I'm not sure he's going to get any sleep today. And Lexa, because not only has she had to get up early in the morning, but she's going to court immediately after we finish this session. So I thank you both especially for taking the time. Thank you very much to all of you.
Thank you.
Thank you.
Thank you very much.